Hi, everybody. Welcome. And thank you so much for joining us tonight to celebrate Lise Olsen and her new book, Code of Silence, Sexual Misconduct by Federal Judges, the Secret System That Protects Them, and the Women Who Blew the Whistle. She is in conversation tonight with Booksmith BFF, Lara Bazelon. My name is Evan Karp. I am the events manager for Booksmith, and we are an independent bookstore and a mainstay of San Francisco's Haight-Ashbury district since 1976. I want to thank you all so much for being here. Without further ado, I'm going to introduce tonight's stars. So Lara Bazelon is an attorney, journalist, McDowell Fellow, former public defender, and professor at the University of San Francisco School of Law, where she holds the Philip and Muriel C. Barnett Chair in Trial Advocacy. She's also the author of Rectify, The Power of Restorative Justice After Wrongful Conviction, the legal thriller A Good Mother, and the forthcoming nonfiction book, Ambitious Like a Mother, Women, Ambition, and Motherhood. And her writing has been published widely in the New York Times, The Atlantic, Slate, The Washington Post, and many others. We've had the pleasure of hosting Lara for the launches of her first two books, and so happy to have her back here with us tonight. Lise Olsen, tonight's star, is a senior investigative reporter whose work has appeared in the Texas Observer, Inside Climate News, and the Houston Chronicle, as well as in documentaries on CNN and A&E. Olsen has more than 20 years experience specializing primarily in crime, corruption, worker safety, and human rights. She has extensively covered federal judicial corruption sagas, including the initially secret sexual assault complaint and subsequent impeachment of a federal judge, as well as other misconduct cases. Her reports have inspired laws and reforms, spurred official investigations and prosecutions, restored names to unidentified murder victims, and freed dozens of wrongly held prisoners. You can follow her on Twitter at Lisa Digger. Congratulations on the book, Lisa. And Lara, thank you so much for leading the conversation. We're thrilled to have you both here with us tonight.
Thank you so much, Evan. I love being back, and I'm honored to be a BFF of Booksmith. And Lisa, it's wonderful to be in conversation with you about Code of Silence, and a subject I think that you and I both have strong opinions and feelings about. I wanted to start by talking about the process of chasing the story, which I think began with you discovering the story. So maybe you can tell us a bit about that.
So I moved to Houston in 2003 from Seattle. Who does that? But it was partly because an editor said to me, you know, the Texas investigations, there's a lot of low hanging fruit. And when I got here, there were a lot of crazy stories that I started investigating that seemed hard to believe, but really this one was the most hard to believe. I was in the newsroom on a Friday and I heard a rumor, and I'd like to read from the very beginning of the book about what would happen that day. So Houston is a humid, heavy breathing city where news takes no break, even as quitting time approaches on a Friday. I was absorbed in notes for another investigative story in our bustling newsroom in March 2007, when the deputy managing editor, George Hadge, waved me inside his private office and shared one of the most improbable tips I had ever heard. He told me that Harvey Rice, another senior staff reporter, had just called with a tale of something that a source had witnessed inside a federal courthouse on Galveston Island. That afternoon, a woman had run crying from the chambers of U.S. District Judge Samuel Bristow Kent with her clothing in disarray. The tipster identified her as the judge's top assistant, Kathy McBroom, known as a normally unflappable court employee and Judge Kent's longtime case manager. After leaving his chambers, McBroom never returned to her own office. Instead, she detoured to another floor, apparently to hide from the judge. Some co-workers believed that Kent had sexually assaulted her. Perhaps if I'd worked elsewhere, I might have automatically rejected that rumor that a man sworn to uphold our laws would violate them inside a so-called Palace of Justice. But I was an investigative reporter in Texas, a place where the improbable often occurs. I plopped down at my desk and kept my voice low as I called Harvey Rice to follow up. This was such a sensitive subject, I didn't want even colleagues to overhear. Rice lived on Galveston and is well connected there and in federal courts. But before coming to Texas, he had worked for the Clarion Ledger in Mississippi. During his time in Jackson, he'd been assigned to investigate rumors involving another powerful judge named Walter Nixon, no relation to the US president. Nixon, rumor had it, had accepted a bribe to help a business associate's son beat drug charges. Rice tracked down sources and ferreted out documents. Nixon, though, later beat the rap for bribery, but was convicted of perjury for lying to investigators and then went to prison. But he refused to resign and continued to collect his judicial pay as a prisoner, Rice told me. He just alerted me to the unusual level of power we were confronting. Federal, circuit, and district judges such as Kent and Nixon are appointed for life under Article 3 of the Constitution. They cannot be removed from office by anything less than impeachment by the U.S. House of Representatives and removal by the U.S. Senate. Even if Kent had sexually assaulted his employee, I wondered, how could we possibly confirm that? It was a classic he said, she said situation. Kent certainly wasn't going to talk, and McBroom seemed to have vanished.
One thing that intro makes really clear is not only the power of holding an office, the office of being a federal judicial officer, but also, and relatedly, how difficult it is to investigate these kinds of allegations. And part of that is because it's so difficult to come forward. And as you say in your introduction, McBroom, the woman who was allegedly assaulted, vanished. So I'm wondering what you did when you came up against roadblocks like that and the hesitancy of many people who he had adversely affected, not wanting to come forward and speak out against him because he was so powerful.
So Kent was the only judge in this, smaller district. He was the only district judge. So he literally called himself King Kent, and people were really afraid of him. One of the first things I did was I called lawyers, people I knew like you who could practice before Kent. And I asked them, have you ever heard any rumors or anybody ever complain that he had treated a woman like this or had treated anyone else like this outside of court? And to a person, almost every attorney that I spoke to said that they had heard stories or they had witnessed things about Judge Kent, not necessarily sexual misconduct in every case, although some had seen him act strangely at parties toward women, try to kiss them, things like that. There's just a pattern of abuse of power that they were describing. And most of the people immediately assumed that this was true, that this woman probably had been sexually assaulted. I started then trying to track down ex-federal court employees because I soon learned that there was a investigation going on at the federal courthouse, but it wasn't an FBI investigation. It was an investigation being conducted by the judges. And the judges had told everyone in the courthouse not to say anything. So the only people I could speak to were members of the bar or former employees. And so I tracked down some of the former employees of this judge, and they told me some amazing and scary stories, really. I mean, two of which I eventually published. One was a law clerk who in the mid-90s, when Kat was a relatively new judge, had been attacked by him, forcibly French kissed. And she had then, in horror, gone to the federal marshal and told him. And the federal marshal had sort of said, well, you can complain, but he's a federal judge. And, she's a lawyer beginning her career. And she didn't pursue it. In fact, she had never even told her husband at the point I talked to her about it. She'd never even told her husband about it years later. And so this was the kind of thing I was confronting in my first initial run on trying to figure out whether we could put together a story about this. So for the first 3 months or so, I gathered string like that, as we say in journalism. I got a lot of off the record and background stories. And I had two women, both federal court employees, former federal judge employees of Kent, who were willing to talk to me either on the record or off on background, which means I could describe them as a former court employee, but not quote them by name. But I didn't have anyone confirming what had happened to McBroom, which was the most important thing. I just had a lot of people saying that they had witnessed her running from the judge's chambers with her clothing in disarray. So how was I going to get that? I figured really what would happen, and my editors did, is that the judges would take action. If that had really happened to somebody in their court, the judges would take some sort of significant action and we would find out about it. And indeed they did. On yet another Friday, we got a reprimand from the Fifth Circuit, but it said almost nothing. It said, that there was some sexual harassment of employees. That was it. There was no details. There was no information. A lot of people who were friends of Kent's, started sort of making fun of the order. It actually said something like, we're not going to disclose the details ever in the order, which was really bizarre. And that just kind of, as an investigative reporter, when somebody says, I'm not going to tell you, that just makes me want to dig harder. So I actually went and knocked on McBroom's door. She couldn't talk to me, but I did something that I don't regret, which is I said to her, first of all, if you are the victim of a sexual assault by a federal judge, I think there's hardly any other story that's more important for me to confirm and write about, and especially if the other judges are going to let him get away with it and not tell anyone. And, so I conveyed that message to her face to face, even though she couldn't talk to me. And I told her that I was going to try everything I could to make sure that this wasn't covered up if that is what had happened to her, because, I know how sexual assault victims suffer. So after that, I ended up figuring out a way to publish the story by determining that, technically the court had told everyone not to talk, including McBroom, but there was a period before that where she would have told other people. And I was thinking, well, who would she have told? Best friends, her mother, or whatever. I ended up talking to those people, her best friend, her mother, who told me that some basic outlines of what had happened, that Kent had assaulted her not once, but twice in the courthouse, and that the complaint had included that information. So we wrote a story saying that that's what had happened, and that there had been previous complaints by other women. And then a day after that, members of Congress called for the Fifth Circuit to reopen their investigation and for there to be a criminal investigation by the FBI. So that started the whole process of the criminal investigation.
I think too, it was really the criminal investigation that blew the case wide open, because as you say, what had happened was that the federal judges had been the people investigating it. So basically they were investigating their own colleagues, and that's how the judicial discipline system works. And I should say, for people who are not well versed in this, that these rules do not apply at all to the 9 justices on the Supreme Court. So they can't be investigated and disciplined in any way, at least not by other judges. But for the lower court judges, including the ones on the trial courts, there is this process where there can be what's called an informal investigation, where the chief judge of their circuit can gather together a committee of other judges to kind of look into these allegations. And that's what happened with Judge Kent. And interestingly, the chief judge of the Fifth Circuit was a woman, Edith Jones, but Judge Jones was actually quite hostile to the idea of sexual harassment in the workplace as a thing. And it's also interesting that, among other things, this order calls an assault a harassment, which is a strange misnomer. And then basically, as you say, tells everyone involved that they're not allowed to speak, essentially silencing them. And I think really, had it not been for your reporting and drawing the larger attention to it, it's unlikely really that there would have been law enforcement attention paid to this case. But I'm curious to know, without giving it all away, kind of what happened from that point. And also, I think, interestingly, you set up this battle between these 2 very colorful, high-profile lawyers in Texas.
So what happened to Kent, you mean? Or what happened behind the scenes with the judicial investigation? Kent eventually, was prosecuted. There were a lot of twists and turns, which I tell about in the book. It was not an easy process. He went kicking and screaming the entire way. He had a very famous defense attorney, Dick DeGuerin, who also happened to be Robert Durst's defense attorney, who got Durst off of murder charges in Galveston. He was defending Kent very aggressively, and he was painting Kathy McBroom, the woman who had run from his office, as a woman scorned, a woman who supposedly had wanted him. And then later, much later, when another victim emerged, he tried to say, well, that was an affair of the heart. So there was a big public relations kind of campaign, and there were attacks on the victims that happened. And the book reveals that really it was a really strange set of circumstances that forced the second victim to finally go public, that involved Kent really committing some other improprieties with other lawyers and ex-law clerks that were men. He would go to strip clubs. He would, take gifts that he didn't fully report, things that are now, the subject of the Wall Street Journal articles, are things he also did. He would not recuse himself in cases involving close friends. So that was a pattern of his too. But anyway, he eventually did get sent to prison, and he was impeached by the House, and that made him resign. So, I mean, but he was like Nixon. He didn't resign until he finally was convicted and sent to prison. So he was also collecting his salary in prison. But anyway, so that's, so he became the first and only judge in our history to be impeached for sex crimes.
It's interesting, though, ultimately, he didn't have to plead guilty to a sex crime or register as a sex offender, even though, as you detail, he was wreaking a trail of havoc and I think creating a real culture where he was harming a number of people. It's interesting, too, because I think, you and I have connected around this issue before there was the Me Too movement. And in fact, all of this conduct that you've been describing is pre-Me Too, which makes it even all the more extraordinary. I think that Kathy McBroom was finally able to come forward and tell her story. But it doesn't surprise me, given the time that it happened, that those kinds of attacks on her were not just expected, but kind of tolerated, I think, in public, that she would be the so-called scorned woman, where when you look at the facts and circumstances, that's quite obviously not the case. You and I connected over this because I was a federal public defender, which meant that I practiced in federal court in front of federal judges. Although I did so in Southern California, not in Texas, there was plenty of misconduct happening there. And there was a judge on the trial court in Los Angeles who was quite a rogue judge and was constantly doing things that were improper and unethical. And yet it seemed to me that nothing ever happened to him. And even when he was finally investigated, similarly to Judge Kent, it seemed like the Ninth Circuit went out of their way to cover up for him, even though what he had done was so, in my view anyways, clearly wrong, albeit not of a sexual nature. And I think that's how we first connected.
Yeah, absolutely. So, when after I covered Kent's case, I became very fascinated with this weird process where judges judge each other secretly. And I started looking at all the documents all over the country and other complaints. And like you said, there was a complaint in California where initially it had been apparently, covered up. And the funny thing was, the judge who had complained about the kind of the way it was mishandled was a judge named Alex Kaczynski. And by the time I started working on the story about Judge Kent, there was a big kind of kerfuffle in Los Angeles, in the LA Times front page story about Kaczynski having a explicit video and photo collection. Some people called it porn. Some people said it wasn't really pornographic, but it was certainly explicit, that he kept on his court computer and that he sent around to people. But at the same time, weirdly, he had been kind of like a person who was a defender of or more disciplinary action or more prompt action in the face of misconduct. So he referred himself, his investigation about himself, to someone else. But yeah, you and I connected because we were both fascinated with this weird insider reviews. And you had written this great article, which you called Putting the Mice in Charge of the Cheese, which I thought was excellent. Talking about how basically, if you put judges over reviewing complaints about other judges and you say, you don't have to tell anybody what you find in your complaint, in your investigation. You don't have to tell anybody what you did after you finish your investigation. And even if you would discipline a judge, you don't have to tell the public why you disciplined him, like they did in Kent's case. Then that creates a system that's almost like it's a shadowy system that certainly doesn't work very well. I think there are cases where judges did a good job in their behind the scenes weird way, but there are also cases where they did not. And I would argue that, that's one of the reasons I decided I wanted to write this book about Kent, is because I felt like that case and what went wrong, why McBroom's complaint was not handled correctly, was a cautionary tale about that system itself and how other complaints that were serious were getting through or being covered up, and that it needed to be fixed. And I think both of us felt that way. You wrote really about the Kent case at the time, and you said there were things that needed to be fixed. So
Interestingly, most of them have not been fixed at all. And in fact, the federal statute that authorizes the process that we've been talking about is utterly unchanged. We can get to that in a bit. But speaking of just the process, I mean, I think it's worth going back to what happened with McBroom. And I would just ask maybe that you read another excerpt from your book about exactly how this committee, led by Chief Judge Jones, investigated or maybe failed to investigate these really serious allegations, because I think it says a lot.
Yeah, and I'm going to just remind people that at every circuit, the chief judge is in charge of doing these reviews. That's whoever it is who happens to be chief judge. In the Fifth Circuit in that year, it was Edith Jones, who at one point was considered for the Supreme Court, but was rejected in part because she was so conservative. The reviews were considered too extreme, even by the two presidents Bush. One of the things she had done was she had said to a woman in a sexual harassment case, well, your client wasn't raped, was she? And that seemed to be her standard for sexual harassment. If you weren't raped, it wasn't harassment. So anyway, so Judge Jones forms this 3-judge committee to investigate McBroom's complaint. And we've established that she's basically like a climate change denier, but for sexual harassment. And she runs the investigation. So you would think that she would want to have the information from McBroom face to face. But instead, here's what happened in July 2007, when the committee meets to investigate McBroom. And in fact, they also talk to the judge's secretary, who is also a victim. They talk to the judge's secretary first. Her name is Donna Wilkerson. So as the Fifth Circuit's investigative committee began, they hired a man named H. Alston Johnson III, a Baton Rouge-based attorney who had no experience in investigating sexual misconduct and sexual harassment. In July 2007, the judges on the committee and their attorney arrived in Galveston to question Wilkerson in person and under oath in a closed hearing. This is the judge's secretary, Donna Wilkerson, who was a victim. Wilkerson knew the lawyers, but asked for no one for advice before facing the committee in a conference room in a beachfront hotel. Its members asked directly about Kent's behavior and about Kathy McBroom's allegations. Her inquisitors included Judge Jones, the formidable chief judge of the Fifth Circuit, and 2 other judges. Under questioning, Kent's secretary stuck to a pared-down version of events. She acknowledged that the judge had kissed and hugged her a couple of times, but the contact was unwanted. Her witness statement remains secret, but Wilkerson later recalled saying, yes, he was inappropriate with me, but it stopped, I handled it. Her statement hid the truth, though Kent did stop his advances toward Wilkerson off and on. She much later admitted to the federal criminal investigators that he had propositioned and groped her on days he'd been drinking over a period of 5 years. Sometimes he came up behind her, grabbing her breasts. Other times he pressed her into a hug and grabbed her bottom. There had been other episodes of full-on sexual assault that Wilkerson did not mention in her first visit with the judges in July 2007. But investigatory committee members did not press her for details of Kent's, quote, inappropriate behavior. It did not seem all that interested in his behavior toward her, Wilkerson thought. Instead, they wanted to know about McBroom. How did she act at work in Galveston? How did she dress? Was she a flirt? Though Wilkerson supported her judge, she found their questions bizarre. Later, Wilkerson wondered why no one ever asked whether Kent, her boss, had pressured her not to testify or whether she would like a transfer. No one ever came to my rescue, she said. No one asked me, do you want to be reassigned? That month, some of the same investigative committee members also traveled to the Hyatt in downtown Houston to question McBroom privately. McBroom arrived with her husband, Rex, who'd taken a day off to accompany her. Nervous and unsure about what to expect, the pair rode an escalator encased in the hotel's towering glass atrium and found their way to a small conference room. Minutes later, 2 judges entered through another door. But Judge Edith Jones was absent. Her office was only blocks away, and there was no explanation. Johnson took the lead in questioning. I'm going to skip a little bit ahead here. But then the judges also asked questions. They inquired directly about McBroom's professional and personal relationship with Kent. They wanted her to describe the outfits she wore to work and to exercise. Were her clothes revealing? They asked whether she dated other court employees and whether she cheated on her husband. They wanted to know about outings to happy hours at local clubs and restaurants. McBroom was perplexed by the investigator's seeming obsession with her wardrobe. On the day she'd been attacked in 2007, this is a day when Kent had pushed her head down towards his crotch and partially disrobed her. She remembered wearing a pair of black pinstripe pants and a blue sweater with a black cardigan over the top. She'd also been carrying a pile of court orders for Kent to sign. What did that have to do with anything? When members of the panel got around to asking about details of that attack in Chambers, which McBroom had already described in her testimony and her written complaint, they asked McBroom and her husband to stand and provide a demonstration. They wanted McBroom to guide her husband so that he could physically reenact the way Kent had grabbed and groped her. Rex McBroom had heard those sort of details directly from his wife, but being asked to perform a kind of play in which he depicted the judge he hated was horribly awkward and emotionally painful. Though Max accompanied her and continued to support her, the McBrooms were living apart. Now they felt they were being compelled to recreate an event whose trauma had strained their relationship to the extent that both feared their marriage would not survive. Rex was so reserved that communication had been a serious problem in their marriage. He wanted Kent held accountable, but disliked being ordered to perform before such an audience. He thought the judges overseeing the probe had assumed a self-protective mode. It seemed like a secret society. They were trying to interrogate her to protect their secret society, he said.
That passage is disturbing on so many levels. The idea that you would ask someone who survived that kind of assault to reenact it with her estranged husband is just beyond words. And really, this happening about less than 15 years ago is incredibly disturbing. I'm wondering if post Me Too, you feel that people coming forward with allegations have been treated differently. And I guess specifically the most prominent example that we have is, as you said, Judge Kaczynski on the Ninth Circuit. And I was wondering if you could talk about that, because that is also part of your book. And then, of course, you know, we had the situation with Brett Kavanaugh, which I'm sure many people are also aware of. But I'm wondering if you could speak to that and just maybe some reforms that have come about as a result, or some attempted reforms.
Well, so that's the reason I decided to tell this book in such detail, because I felt that there were echoes of the Kent case later on. As I mentioned, a lot of people, pretty much, I think a lot of people in California who follow the courts know all about Kaczynski's porn collection, or whatever it was, the explicit video collection. People had kind of laughed it off. But then when Me Too came up and we realized, you know, there were this string of women who were talking about cases dating back 20 years, including a federal judge who said he had groped her in a car, he grabbed her breasts. It turned into something else. And one of the things that I do often as an investigative reporter, and I know lawyers do this too, investigating, is you put a chronology together. And I was very interested in when I noticed that, for example, it was very clear in these reports that had come out in the Me Too movement that actually at the time Kaczynski was investigated for his quote unquote porn collection or explicit video collection, he had in fact been showing those videos to young law clerks in chambers, similar to the kind of things Kent was doing in chambers, you know, showing women images, saying suggestive things. And I'm not saying Kaczynski attacked women the way Kent did, but he did other things that were predatory and, in my opinion, and certainly disturbed the women who were in chambers with him. There are two clerks who've talked about what he did in chambers. one was shown, but two of them were shown images that they found disturbing and sexualized. But anyway, the fact that that had been investigated, there had been complaints about that in the early 2000s. And the judges who investigated those complaints had obviously not talked to those staff members and they had not come forward, disturbed me. And one of the things that I wanted to know, and that's why I tried to persuade everyone to talk to me, was I felt like I wanted to be able to tell the world if other women had been treated in the way Kathy had, which is, first of all, she didn't even know there was a complaint process originally, because even though she'd been a court employee for years, no one had ever told her about the misconduct complaint process. So I asked other women who came forward, Me Too, did you even know there was a complaint process? Did anyone tell you about it? And some of them certainly did not. There were a few that did, but they were discouraged from filing complaints because they were told, sort of like the young clerk in early 90s who had been French kissed by Kent, that that would have an effect on their careers and that they should consider it very seriously. And then there's also this question of, and this is again why I believe why I named the book The Code of Silence. There were all these codes that and handbooks and oaths that different judicial employees and clerks had to take. And some of them made it sound like, I think, very intelligent women who were clerks, including one who had clerked for Kaczynski, Heidi Bond, felt that that compelled her to never say anything about what had happened in chambers, even though he had done these things that were clearly sexual harassment to her. And so that was, to me, there was a really common thread there. You know, the judges are the closest thing we have in our country to the monarchy. You know, they sit up on this elevated dais. They wear their black robes. They are appointed for life. And some people make jokes about the only difference between judges and God is that God doesn't think he's a federal judge, you know, but really that kind of thing is not a joke. If a judge really has that kind of idea about themselves, that can kind of lead to this sort of behavior behind the scenes. And that's why I wrote Code of Silence. I wanted people to see that, and not just people like you who know about the courts and who've been in the judges' chambers, but people who had never been there, so that they could understand why women would be afraid to come forward, why they might fear for their careers, why they might figure that a judge could not only ruin their career in the courts, but ruin them entirely for the rest of their lives. There's another case that's not dealt with in a great deal of detail in my book, but it's another federal judge who propositioned a young woman. She considered it a proposition, and then later sent her flowers in the clerk's office, which made everyone think she was having an affair with the judge, who then resigned and it left her job, left her career, and went into a depressive episode. Lost her entire, her career over that. That was not exposed. That judge was not exposed until 20 years later. That judge, like Judge Kaczynski, had a complaint against him. And around the same time, Judge Kaczynski had all these complaints, and the court said initially they were going to investigate. The Ninth Circuit said we were going to investigate. Judge Kaczynski decided to retire. Well, that cost him nothing. He could retire, keep the same salary, and that would end the investigation. In the case of Judge Walter Smith, who'd done this thing to this young woman years before, he also could resign because he'd retire. He had full pension. There was no real consequence for him. He was at the end of his career. So, and then there was no one who went back and said, well, shouldn't the system be fixed so that we could understand why the chief judge back in the years ago didn't properly investigate that complaint? Shouldn't the system work so that judges who resign are still investigated so we can know what they did and how to fix it? So there have been people who've come forward and said, we should reform the system. We shouldn't allow judges to just retire or judges to be named to the Supreme Court and then not investigate complaints against them. Because that's certainly what happened in the Kavanaugh case too. The Kavanaugh complaints that we all listened to, we heard the testimony of Christine Blasey Ford about Kavanaugh's behavior as a teen. He was at the time a circuit judge subject to this law. We're talking about this crazy secret system, but then all those complaints came in. And as soon as they got in the door, basically the chief judge in the 10th Circuit, who was especially assigned those cases, said, we're not going to investigate. He's now a Supreme Court justice. And as you said, the system does not apply to Supreme Court justices at all. They don't even have a code of conduct. The rest of the judiciary has a code of conduct. They have the secret system. The Supreme Court has nothing except impeachment, which hasn't happened since Thomas Jefferson was the president. That was the last time the Supreme Court justice was impeached.
Yes, it's extremely, extremely hard to impeach anyone in the federal government, I think, as we have seen recently. And, when you're talking about these young clerks not wanting to come forward or wondering if they even can, it's a completely understandable fear, because it was not clear at all, I think, during what was going on with Kaczynski, that someone like Heidi Bond could come forward under this code of conduct that she had signed on to. And basically what it says is what happens in chambers is secret. And I know I was a clerk also on the Ninth Circuit, not for Judge Kaczynski, but for another judge who was a wonderful person and would never do anything like this. But the point is that when you're working for a judge, you're really an extension of the judge. You're there to carry out the judge's will. You're there to write their memoranda. You're there to draft their opinions. You're there to talk through how they're thinking about cases. It's a very, very, very intense, sort of weirdly intimate relationship that basically does happen behind closed doors. Nobody sees what happens when judges and law clerks are all together. And so it really is rife for abuse if you have somebody in a position of authority who has those kinds of impulses. And of course, the clerks tend to be much younger. They don't have a professional life, so to speak. This is kind of the beginning of their career. They're told that getting a federal clerkship is this incredible, much prized opportunity, that it's going to be hugely important for them moving forward with their careers, all of which is true. And so the idea of complaining, first of all, you don't know if you legally can, but second of all, the repercussions just seem crushing and overwhelming, makes it very, very difficult for anybody to say anything. And I think part of the calculus that a lot of clerks have is it worth it? Is it worth it to go through this process, which may not result in anything happening? Or even if it does, for the rest of my life, I'll be known for this one thing and not perhaps for any of my other achievements. And I feel like that's a huge issue. And it's a huge issue for women in many, many, many different professions. But it's particularly, I think, fraught in this particular situation because of what that employment is designed to look like. And it's important that the deliberations and the discussions about the law be sacrosanct, because you don't want to expose the judge's reasoning to the general public, but it can't be that means that they have carte blanche to be abusive. And yet, when Heidi Bond went to seek counsel from another federal judge, he basically wasn't able to tell her that it was okay for her to come forward. And she's someone who is, I think, entirely left the legal profession.
Yeah, and it's so bizarre because that same judge, who is very high ranking, in the judiciary and is respected, he had also been the judge who had investigated Kaczynski's complaint about his porn, or explicit material collection. And so he's in a way the one who missed that Kaczynski was, in fact, showing that stuff to his court employees, that he was not just doing that for his private reasons in his private world. He was mixing it with the court, the business of the court. And so I think there was a little bit of a problem for him in a couple different ways. I mean, maybe he couldn't answer the question, which is what he said to Heidi, but maybe he partly couldn't answer the question because he was a big part of the problem, why that had happened, why that hadn't been detected a lot sooner. Maybe not a big part of the problem, but part of the problem. And this whole the fact that the clerks have to tolerate this kind of behavior, I think, affects men too. There were men who were clerks for, of course, Kavanaugh was a clerk of Kaczynski's. We don't know what impact that had on him. Certainly in Kent's case, Kent used his former clerks to take him to strip clubs. He asked them for favors that I think crossed a lot of ethical lines. And you read the book and you'll find out more about that. And there's still, today, like you said, the whistleblowers face retribution. There's lawyers who were whistleblowers, women and men in my book, who, moved, left a state, because they didn't want to deal with the backlash. There are lawyers who had bar grievances that supposedly weren't related to their complaints, but you have questions about whether they were. And so there certainly is a price that a lot of people pay for being whistleblower Kathy. When she returned to her job, she went to work for another judge who proceeded to make outrageous comments to her and tell her sexual jokes, things like that. She wasn't about to start all over and file another complaint, so she just kind of sucked it up. And that judge has gotten away with a lot of things. But what's funny is when I read your book, read this book, I read this passage about Laura's supposedly fictional judge. And I was very much reminded of the stories that Kathy had told me about this other judge who's not fictional. And I want to read a little bit from your book, from the chambers of the Honorable Dars Ducey, who's a fake judge, but is apparently based on real judges. And her main character, to set this up, is this great lawyer named Abby, who is also a federal public defender who's kicking ass and taking names, and happens to be the parent of a newborn baby and has gone back to work and is taking on a very challenging case. So she goes in to talk to Judge Ducey because really he should be recusing himself from her case because they've had this previous kind of conflict. But of course, he's not going to. She goes into chambers and he says, Abigail, I've missed our banter. She'd forgotten about that laugh, how much she hates it. Odd that childbearing doesn't seem to have softened you any. My wife, on the other hand, she never could lose that 10 pounds after our third one. Got some saddlebags on her now. Abby tried not to let her revulsion show on her face. Then again, Dars is still musing on the theme. You look a bit, how shall I say, inflamed. Then again, at least you didn't get fat in the face. That happens to a lot of women. He puffs out his cheeks to demonstrate. Those last few months, you looked like a garden snake that had swallowed a basketball. Another Anyway, and even that, I thought, well, it could have been even worse, but still, that kind of thing, that kind of this, I am a federal judge, so I can say whatever I want about your appearance to you in chambers or in court. Some of them have felt okay about saying, girls to women in court, or requiring their employees to wear heels. And this thing has not gone away. And it's kind of a piece of, this deeper, I think, cultural change that needs to happen. There's changes that need to happen with the system, the judicial disciplinary system. There's changes that probably need to happen where the judges probably finally need to say, okay, we need to do sexual harassment training, and we need to abide by federal workplace laws like every other government workplace. I don't know that they ever will do that. And there's other things like that could be done. There's a lot of changes that should be done to the disciplinary system. But it seemed to me like when I was researching the book, that one of the big things that needs to happen is a lot more women need to be nominated and need to be confirmed as federal judges, because it's still just way too much of an old boys club. So I'll put that question back to you.
That is so true. I'm like reliving my PTSD. It's funny because one of the critiques of the book is that the judge is not realistic, that he's not believable. And every single thing, with only a few exceptions, that came out of his mouth came out of the mouth of a federal judge, either said directly to me or said to women that I worked with. And I know that's difficult for people to believe, but it is just unreal, the kind of abuse and the things that come out of their mouths, and you're just supposed to metabolize it because you don't have any power. And also because what you're really worried about is what they're going to do to your client if you push back in any way. And so it's just the most out-of-body experience to have a federal judge saying these grossly inappropriate things and not having any way to really push back, either because the system isn't set up to support you, which is true, because actually the system's designed to protect the judge, which is also true, and because you have this ethical obligation which is to your client. And so, you know, in the middle of all of that happening, obviously there's someone you're representing, and you have to really be mindful of their interests, which have to be paramount. And so it's this very difficult situation. And I completely agree with you. I think we absolutely have to nominate more women, and we absolutely have to mandate sexual harassment training. And we also, I think, really need to push hard to make some of these proceedings and procedures more transparent. You know, one of the questions posed to you by Ingrid, is it Lobet?
You bet.
Is whether your reporting led you to think that there was more of this happening in the federal courts. And if the answer to that is yes, I'm wondering what you think or what you see happening that's making you perhaps feel more optimistic about where we're headed with all of this.
Well, I mean, you know, this is the thing is again, I don't think that there are people who are trying to sexually assault women in their chambers all over the country. But I do think that what we call robitis, you know, this abuse of power that some judges display in public or in chambers, and this kind of sexualized behavior that's still unfortunately the norm in some among some judges, you know, it just got to go. And the problem is that when it becomes a very serious issue that should require some sort of disciplinary response, the answer too often is still the judges will just push the log down the road and just hope it goes away and hope no one really finds out what they're covering up. I mean, I think that almost every single serious allegation that I ended up putting, I didn't even put all the most serious allegations against judges in the book. What I tried to do was reverse engineer the serious allegations to determine, did the people who came forward feel they could come forward? Did they know the system even existed? If the system did investigate their complaint, did it work or did it fail? And if so, why? And what was sad was there was really no example of a complaint involving sexual misconduct that had been appropriately handled by the federal judiciary. No, I couldn't find one, not one. And that is a terrible, terrible thing. And then, you know, the Chief Justice said after the Kaczynski allegations in 2017, and again in 2018, this is a priority for the judiciary. We're going to try to fix this. But he put into place a group of judges only to study the problem, only judges to recommend what to do to fix the problems that judges had created. They didn't allow members of law clerks for accountability to come into those meetings. They allowed them to come in, but not to be members. And they didn't ask people like Kathy McBroom what should be done. And they probably should have. You know, they seem to have forgotten all about a judge that sexually assaulted 2 of his employees, and how the Fifth Circuit really, by not dealing with a lot of other prior complaints, allowed him to still be in a position to do that. And then once the complaints came to them, didn't act soon enough. So I don't know, you know, so Ingrid, I don't think every judge is like this, but I think every judge in every courthouse in the United States who cares about the judiciary should not be in the business of trying to cover up things like this or not deal with it openly. We should be rooting it out, fixing the system, making sure the public has trust in the judiciary and knows that these things will be addressed. And young women who have this happen to them should not be, or young men should not be afraid to come forward. They should know that they can and that it will be fixed.
There's a question from my lovely friend, Sonia Nazario, who is a wonderful and amazing journalist and the author of Enrique's Journey Among Many Important Pieces. And she writes, what percentage of judges are women? And I don't know if you know that, but I'm going to be the little apple polisher and answer if you don't know. The answer is roughly 1/3. And that number got skewed a bit because when Donald Trump was president during those years, he appointed very, very few women. His nominees were overwhelmingly white and male. So the federal judiciary balance got pushed. And actually, there are more female judges on state courts than there are in federal courts. And, you know, hopefully this administration will really try. I think they are trying to correct a lot of imbalances in the judiciary, including the gender imbalance and also just the range of life experience that these judges have.
I
And
think
we're also skewing younger, but yeah, go ahead.
this was a number I really obsessed about, Laura. And I think you're right. It's like somewhere around 30%. But if you include all of the senior judges, I think you slip down a little bit closer to 20. And to me, what's shocking about it is that was the percentage it was in like 1980, mid 80s. Really, I mean, that is terrible, because if you look at, that's very disappointing, because you look at, President Carter was the one who really tried to do something about women in the circuit courts. He appointed more women to the circuit courts than just about, I think, any other president. I don't know exactly, proportionally anyway. And he tried to take aim at that. I don't think anyone else has really looked at that as an issue that way. The diversity of the judiciary for sure has been an issue, but you see this women in law schools getting to 50-50 or even a majority in some, and yet you see that 80-20, 70-30 in the federal judiciary, which I think is dismaying. And I think it's part of the problem. It seems like it's part of the reason that things are the way they are.
Yes, 100%. Although, no, I'm not angling for a judicial appointment. I'm very happy where I am. This question is from, okay, I'm gonna butcher your last name, Ruth, and I really apologize. From Ruth Tykerobe.
Ruth Tykerobe, yes.
Okay, great. And this may end up,
another great journalist.
This may end up being one of our last questions because we're almost at time, but she wanted to know what the hardest or most challenging part of writing this book was for you.
Really, I mean, there were a lot of things that were challenging. Knitting together all the women's stories in a way that was fair to every woman was really important, and fair to every judge. I mean, it was important to me to be fair to the judges. Interesting thing about working on a book for this long is that people, their initial reflections on their experiences may be much different than how they look at it a year later or 5 years later or 10 years later. So I really tried, there's a lot, maybe more than I needed, flashbacks and flash forwards in the book, but I was trying to let the readers know how the women's perceptions changed in some ways about what had happened to them. Not that it, fundamentally things changed, but over time things would change. And that was a challenge. That's a challenge, but I think that helps you at the end of the day understand the meaning and the real commonality of the experiences when other people who you're interviewing can reflect more deeply on what happened to them and not just be recounting facts.
When you say that their perceptions of what happened to them changed, did they all change in similar ways? What do you mean by that?
Well, let me tell you one example that was important to me. So Heidi Bond, when she recounts how she first went into Kaczynski's office, her first day as clerk, and he had her recite an oath to him, take an oath in front of him, and he immediately said, you're my slave. She had a certain response right away that was very visceral, like, no, I'm not, and later on, when she had written about that, she'd written about, well, of course, slavery, has nothing to do with being an elite federal judge. But when I talked to her about it, she said, well, if you put that in the book, that's not what I thought at the moment. And what I thought at the moment was, that was a really fucking unbelievable thing for a judge to say to me, as a young woman. It wasn't, I didn't have that deeper reflection. I do now. So that was, that was a moment there. So that's something, I think when you write a book and you're really trying to get into other people's heads, and people have complicated thoughts about these things, that you really want to try as hard as you can to understand the layers that are there.
Do you think that Kathy McBroom feels that justice was done in her case?
Well, I think Kathy and Donna both were, as you said, I mean, Kent was impeached. He was impeached for sex crimes. He was impeached for everything he did. But when you look at the indictment, versus what he was convicted of, he was really only convicted of perjury. He's convicted for lying to the judges in their investigation, in their secret investigation. That's what he was convicted of. That was, in the end of the day, the most important thing to get him convicted of, apparently. He had to admit that he had sexually assaulted these women, sexually committed these crimes. There were different degrees of assault in each case. But he did not have to plead guilty. He doesn't have to be a sex offender. He did lose his law license. He's disbarred, but he's living, off the retirement life. Nobody probably among his neighbors knows this story. Maybe they will now, but yeah, he wasn't convicted of any of the sex crimes.
Well, if they didn't know the story before, thanks to your book, maybe they will know now. And maybe, you know, routine things like taking out the garbage will be a little bit more fraught for Mr. Kent. We are at time, so I just wanted to say thank you so much. I loved being in conversation with you. This book is wonderful. It reads like a thriller, and I highly recommend it. I highly, highly recommend it. As Evan said, it is easily purchasable at Booksmith and also wherever you find your books. And Evan, I didn't know if you wanted to come back for a minute to just sign off or whether we're good.
But I wanted to say one more thing is I think it's
Sure.
even more important for Kathy that her story make a difference in general, that the system, you know, be changed beyond, you know, her view of what happened to Judge Kent. She'd like the system to change. She joins in the calls of 2017 that something needs to be done here. Sorry about that, Emmett. Back to you.
No, not at all. I'm here for you, and gladly so. Thank you so much for being here, and congratulations on the book, Lisa. And I hope you all have enjoyed this conversation, and that you have this crucial book already. But if not, as Lara said, click through the link beneath the video, and you can get it from Booksmith. If you're tuned in from far away, well, I need to spotlight you. That's it. And you can get Lara's books too. Click through, the links are just beneath the video. If you have a favorite neighborhood bookstore that's far away from us, get it from them. Just get the book. That's the important thing. Lisa, thank you for writing it, and congratulations. Thank you all. Take care, and stay well out there. Thanks for joining us.
Everyone. Thank you, Lisa. It was great
Thank you,
to talk
Lara.
to you.
Great talking to you. Hope I get to see you in person next time.
Me too. And thank you for the shout out. Good night.
Night.
Good night, everyone.